Hi everyone. In January 2025, the Department of Education began writing to primary and secondary schools across the country to advise them of a change in data protection law, which required schools to disclose information to the HSE about every child enrolled in their school, stating that the HSE required this information for the HSE's school health programme, which includes the following: hearing and eyesight screening, dental checks and vaccines, with the suggestion being that the HSE needs this information to allow them to contact parents directly, instead of parents being asked by the school to complete consent forms as and when different screenings were taking place. On foot of this notification from the Department of Education, some but not all schools began writing to parents to advise them of the school's now updated legal obligation to disclose information to the HSE, irrespective of any parent's non-consent to such disclosure, and irrespective of whether any parent does not intend to consent to their child participating in the HSE's school health programme, whether in part or in full. The purpose of this video is to explain the change in law and to make you aware of its potential consequences. So, on the 17th of December 2024, Stephen Donnelly, the then Health Minister, signed two statutory instruments into law, namely SI number 750 of 2024, Health Provision of Information for Health Examination and Treatment Services, Regulations 2024. I'll refer to this as Regulation 750 going forward. And SI number 735 of 2024, Infectious Diseases Amendment number 3 Regulations 2024, and I'll refer to this as Regulation 735 going forward. Regulation 750 states that where the HSE makes a free health examination and treatment service available to pupils who attend primary school or who are taught at home, the HSE can request the following information from the school for any child attending that school: the name, address, date of birth and sex of the pupil, the birth surname of the mother of the pupil, the name, phone number and email address of the parent or guardian of the pupil, the PPS number, if any, of the pupil, the name of the school which the pupil attends, and the school roll number for the pupil. Together, I'm going to refer to this as the requested information going forward. Regulation 750 goes on to say that where the HSE makes any such request of a school, the school must deliver the requested information to the HSE within 10 days. Now, Regulation 735 states that where the HSE makes a vaccination programme available to children who are enrolled in a school, the HSE can request the same information just discussed from the school for anyone who is enrolled in the school and who is eligible to receive vaccination. Regulation 735 goes on to say that where the HSE makes any such request of a school, the school must deliver the requested information to the HSE within 10 days. So the question is, why has the Minister for Health enacted Regulations 750 and 735? Well, the General Data Protection Regulations, which we will refer to as the GDP regulations, which came into force on the 25th of May 2018, lay down rules relating to the protection of persons with regard to the processing of their personal data. The recitals to the GDP regulations state that the protection of natural persons in relation to the processing of personal data is a fundamental right. So, in order to lawfully process data, which includes the sharing of data between a school and the HSE, the school must first determine a legal basis for the processing or sharing of such data under Article 6 of the GDP regulations, which is limited to the following. 1. The data subject has given consent to the processing of his or her personal data for one or more specific purposes. 2. The processing is necessary for the performance of a contract to which the data subject is party, or in order to take steps at the request of the data subject prior to entering into a contract. 3. The processing is necessary for compliance with a legal obligation to which the controller is subject. 4. Processing is necessary in order to protect the vital interests of the data subject or of another natural person. 5. Processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in the controller. 6. Processing is necessary for the purposes of the legitimate interest pursued by the controller or a third party, except where such interests are overridden by the interests or fundamental rights and freedoms of the data subject, which require protection of personal data, in particular where the data subject is a child. So, in order to be able to legally compel schools to release the requested information in respect of your child, the Minister for Health had to enact laws so that schools could avail of the Article 6 exception of processing is necessary for compliance with a legal obligation to which the controller is subject, by saying that A. The school has the legal authority to release the requested information under Article 6 of the GDP regulations by virtue of the enactment of Regulations 750 and 735. B. The school is legally required to release the requested information by virtue of the enactment of Regulations 750 and 735. And C. Neither the parents, guardian nor the child in question has any legal basis to refuse to allow the school to release the requested information by virtue of the enactment of Regulations 750 and 735. So the next question is, why does the release of the requested information give rise to a cause for concern? Well, many general practitioners and the HSE have treated parents and guardians with contempt and ridicule when they have chosen not to vaccinate their children against certain illnesses, noting that this contempt and ridicule became amplified during the rollout of the COVID-19 injections. Since 2021, I have received considerable communication from parents who have been pressured by doctors, nurses and HSE staff to administer different vaccines to their children, and I fully believe that the disclosure of the requested information is another avenue they intend to exploit this aim further. For instance, I am regularly contacted by concerned parents who have been advised by their GP that they must, as in it's not optional, complete a primary childhood immunisation schedule declination form in circumstances where they do not want their child to receive certain vaccines. In many cases, the GPs in question will repeatedly contact these parents by phone and by email, insisting that they must complete the form, sometimes suggesting, but often insisting that the completion of the form is mandatory. In every such case, I advised parents against the completion of this form, as this form asks you to acknowledge the following. I acknowledge that I am aware of the following facts. So when you sign this form, you are accepting that the following points are facts. 1. I understand that the primary childhood immunisation schedule will protect my child from list of illnesses. 2. I understand that by not having the primary childhood immunisation schedule, my child will be at risk of contracting vaccine preventable diseases. And 3. I understand that by not having the primary childhood immunisation schedule, my child can spread these vaccine preventable diseases to other vulnerable children and adults. So by signing this form, you could be acknowledging that you agree that you are both endangering your child and the children of others. Please note that you are under absolutely no legal obligation to sign this or any other vaccine rejection form, whether from your GP, the HSE, your child's school or otherwise. Now, the reason the disclosure of the requested information is concerning is because up to this point, the majority of communication and pressure concerning childhood vaccination would have come directly through your child's GP. Whereas I have little doubt that the intention behind this change in law is to create another avenue whereby parents can come under increased pressure and scrutiny to administer so-called vaccines to their children through direct contact by the HSE. And I also have little doubt that parents will be advised by the HSE that they must complete the primary childhood immunisation schedule declination form where they do not consent to their child receiving certain vaccines. In this regard, I would again remind you that through the passing of the Children's Referendum in 2012, parents agreed that where they fail in their duty towards their children to such an extent that the safety or welfare of any of their children is likely to be prejudicially affected, the state as guardian of the common good shall supply the place of the parents. So my strong advice is to be careful what you sign because you never know how it could be used against you into the future. To conclude, I would suggest that you contact your child's school to see what, if any, information they have or are in the process of disclosing to the HSE about your child, and be aware that you may start to come under increased scrutiny from the HSE in circumstances where you have refused to allow your child to be administered with so-called vaccines with which you do not agree. Thanks for listening.